Hello, good afternoon, everybody. Thank you for joining us. We have Nasir Adil has a great training planned for you today on recent trends in workers' compensation defense. We also have JP and Jessica here joining us, and they're going to introduce themselves in just a moment. Let's get into the fun stuff and meet our B&B team. Let's start with JP.
Hello, everyone. I'm JP Torres, the managing attorney of the San Jose office. We primarily handle here all Bay Area boards, Salinas, San Jose, some San Francisco and Oakland, even as far as Stockton. If you have any questions, I'd be happy to help. My contact info is there, panels, what have you. Or, who is that applicant attorney I never heard of? Just give us a call and I'd be happy to help. Fun fact about me, if you've seen me on these presentations before, I love coffee. I am pretty familiar with all the great spots, where to get coffee, etc. And I'll pass it along back to the next person.
Jessica.
Ready? My name is Jessica Bear. I'm an associate attorney with the San Jose office. It's nice to be here. Thank you for having me. And I also deal with the same board and jurisdiction that JP just said, so I won't repeat that. And fun facts about me, I love going on road trips, especially to national parks and going snowboarding. So anything outdoorsy in the great state of California, come talk to me.
Awesome. I love snowboarding. Okay, Nasir, are we ready?
I think so. I think we're ready.
All right.
All right.
You're up.
Thank you. Good afternoon, everyone. Thank you for joining. My name is Nasir Adil. I am the managing attorney of our Oakland office. Our Oakland office primarily covers the Oakland and San Francisco boards. We also cover Stockton. Of course, in this post-COVID world, we can and do cover pretty much whatever and wherever. So if you have any questions, by all means, that's going to be the theme of today. Reach out during the during this webinar. Reach out to us if you have any questions that pop up. Those are being monitored. We can interrupt and answer accordingly. After, if you have any questions that pop up later, that's fine. Feel free to email any one of us and let us know if you have any questions that can relate to, hey, I have a panel that came in. Who do you recommend striking? Hey, I need a rating to be done. Obviously, our firm is here for you whenever and wherever. As far as a roadmap for today, we're going to be talking a lot about trends in workers' compensation. Primarily, we're going to talk about settlements and CNRs. We're also going to talk about panels and some of the recent trends that have come up specifically regarding Labor Code Section 4060. Those will be the majority of the time we'll spend today. And at the end, hopefully we'll have time. We're also going to talk about a topic that we all deal with, kind of a specific topic, but one that does come up frequently, is aggravation and exacerbations, and kind of the distinctions that we can kind of deal with those two topics right there. Obviously, when it comes to settlements, when it comes to panels, and when it comes to issues like causation, we can spend an hour plus on each of those topics, probably way more. But for today, we're going to spend the majority on the first two topics, but down the road, we can expand accordingly on any topic longer if need be. Just feel free to reach out if anyone needs any specific training or requests for us. As I usually do, I start with a joke. I must preface by saying it's never a good joke, but it's a joke nevertheless. All right, so 8 vowels, 11 consonants, an exclamation point, and a comma appeared in court today. They all appeared in court today. They're due to be sentenced next week. Get it? Sentence next. Okay, never mind. All right. So like I said, starting with the bad joke is always preferred. So let's go into settlements. Next page, please, Tammy. All right. We've all seen the exciting first page of a CNR. I mean, we could all go into hours about this, but let's go on. Next page, please. All right. So first page of a CNR, okay? This is the first thing we got to always keep track of. Whenever you see a CNR, whenever you draft it, I don't care if you're a claims professional, if you're an attorney, whoever you are, wherever you are, be accurate, okay? A poorly or incompletely drafted CNR can be identified from a mile away. Those attorneys who are on the line right now, remember when we took Barbary and different bar prep courses, the graders and the teachers always said, if your answer seems off, then the grader can identify that from a mile away, right? Same thing with judges. If your first page of a CNR or anything's off, guess what? A judge is going to probably put their glasses down like this and say, all right, order suspending, something doesn't seem off. So if it seems off right away, chances are the judge is going to recognize that, and you're more likely to get the dreaded order suspending. So make sure you list all the ADJ numbers. If you have multiple ADJ numbers, list them on pages 1, 4, and any addenda. Be complete, be precise, and be complete. It'll save you a lot of headache down the road. If you need to create an ADJ number, do so at time of e-filing. If you need an ADJ, for example, if the AA is pled a specific, and that's what the address record says, but the medicals discuss a CT, make sure you list that CT. So how do you do that? You create the ADJ number. After you get the ADJ number, make sure the CNR has all of them listed, because if the CNR has all of them listed, guess what? The order approving CNR will also list them. Next page, please. Right. If not, we get the dreaded order. We have to do an amended order approving CNR, possibly file for removal, etc. No one likes that. Believe me, that's dreaded by everyone involved. What I recommend doing, it's something simple, of course, but make sure, again, seems like common sense, but make sure you list the proper name and address of the injured worker. Why? Because no one wins when CNR payments are sent to the wrong address. Penalties, interest, unhappy AAs, unhappy applicants, unhappy judges, no one wins. Take the time and effort on the front end to make sure you have the right name and address. And for those of us who are more specific, you can even put into the pages 6 or 7 of the CNR that applicant confirms that the address listed on page 1 of the CNR is accurate for payment purposes. Be clear, be concise, and you won't have to do it again. Next page, please. The beautiful page 2. So perfect in its entirety. Next page, please. All right. So page 2 of the CNR. Just like page 1, make sure you accurately list applicant attorney's information. Straightforward, right? Common application, common sense. Next page, please. The golden page 3 of a CNR, as perfect as the other pages, even more so. Next page, please. All right. So over page 3 of the CNR, okay? I know it seems straightforward, but this is kind of where things tend to go off the rails if you're not careful. Be careful. Don't just ignore things like date of birth, occupation, because if you leave them out, it's going to get an order suspending. Because if it doesn't have that proper information in, then judges are trained, right? They're trained to, hey, if it's not complete, then how can an order approving an incomplete settlement document be issued? It can't. So you're going to get an order dismissed, order suspending. Sure, you can obviously remedy those issues after an order suspending, but it's going to be a headache, right? You're not going to be able to close the file. You're going to keep a file open longer. You're going to delay settlement payments. No one wins with that. So things like body parts, especially on page 3, be complete, and be complete. With body parts, if you're drafting the CNR, you cannot be complete enough. Okay, what does being complete mean? Well, obviously, check all body parts that are alleged. Make sure you're concise. Check the address record. Check EAMS. Check the application. If you literally check what's pled, that's probably a C level. It's going to pass the muster. You're probably going to be complete, but none of us want to do C level, right? We want to get the B or A level. So in addition to checking including what's pled on your CNR, also check the medicals that you're settling based on, right? If you're settling on a PQME or even an impairment report from the treater, make sure you list all body parts that the doctor or the PQME provided impairment for. If you include all those body parts on your CNR, then guess what? You're above average. But if you really want to be stellar, which all of our attorneys are and should be, we want to also include on the CNR page 3 all body parts that are diagnosed. So check the medicals, be complete. If you're complete on the front end, you're going to be very complete on the back end. And no one wants to find out post-order approving CNR that a body part was left out, right? No one wins with that. There's no worse feeling than having to be second-guessed and asked, hey, defense attorney or claims examiner, why did you leave the back out when the back was involved? We've all been there, but the whole point is never to be there again. So be complete, be concise. Don't just learn from your own mistakes, but learn from other mistakes as well. Next page, please. Okay. Be complete. List where the injury took place. If you're not sure, on the page 3 of the CNR, just list job site subject to proof. and then list the city, state, zip, etc. Next page, please. All right. Page 4 of the CNR. So on this page, oftentimes if we have one injury only, then we won't need this page, right? So if you don't need this page, if you only have one injury and you're sure about that, next, just go ahead and slash out page 5 entirely. Okay, if you don't need it, sorry, page 4, go ahead and slash that out and you're good to go. Okay, but if there are multiple injuries on page 4, make sure you list all of the injuries. Okay, make sure you also, if you did get a new ADJ number because you needed one on the front end, make sure that you list that on page 4 of the settlement as well. Don't be incomplete. Make sure you get it all properly. Because again, if you're complete on the front end, then your order approving settlement is going to list all the proper and requisite ADJs. Next page, please. All right. Now we are on to page 5 of the settlement. Okay, page 5 of the settlement is going to be something that we want to be very clear for. And again, none of this stuff is brain surgery, but it just requires a little bit of detail and a little bit of attention on the front end because you can save a lot of time on the back end. Now, what does that mean exactly? Next page. All right, so again, we're talking about page 5 of the CNR, okay? And page 6 we'll be talking about as well. These are the pages that are really important as far as making sure you get everyone on the same page as far as average weekly wages, TD, PD, and medicals, right? So one thing I like to put on pages 5 and page 6 of the settlements, you can even type it in, just put the language, payments are subject to proof with jurisdiction reserved. Why do we do that? Well, because if there's ever any discrepancy as far as PDAs or TD or anything, then you can always kind of go back to the board and resolve those issues informally. Also, by doing that, it also keeps everyone's on the same page. Oftentimes, AAs or applicants, they don't have all the updated indemnity information. So they're kind of relying on us, defense attorneys and claims to kind of be honest, of course, when we're listing the PDAs. That way it keeps everyone honest and it preserves any rights to amend the CNR for afterwards. So next page, please. All right. So practice tip, again, be concise, be clear, and you won't have to do it twice. One thing that I recommend for all attorneys and as well as claims is this is when the defense attorney should be reaching out to claims, say, hey, look, claims, great news, we have a CNR ready to go. How can we make sure that we properly list all the information? Well, that's when we reach out to you all and say, hey, look, please send the benefit printout, but also please confirm TD, PD, and medicals paid. What does that mean? Well, for TD and PD, get the total amounts, right? Very important. Also get the rate that those respective payments were paid at, okay? And also get the dates they were paid at, okay? Those simple things like getting on the same page keeps everyone on the same page, not just defense, but also applicant's attorney. Because when you're clear and concise, you have to realize not only does the settlement have to pass the applicant attorney's eyes, but they're also explaining these terms to their clients. So when everything is properly laid out and showing that, hey, look, this is an indemnity paid, you have less likely confusion by the applicants who tend to forget that, hey, I did get and I did cash thousands of dollars of PDAs. Miraculously, guess what? They did get cashed. But oftentimes, if you don't properly list that, then that can't be explained by applicant's counsel to their client that, hey, look, you did get this money, hence the deduction that defendants are allowed to get credit for, right? One other practice tip, I think benefit printouts are great, but I'm sure if I asked every defense attorney to raise their hand as far as who has trouble reading those benefit printouts, I think we'd all be having our hands super high in the air. Benefit printouts are great. We love getting them. There's regs and labor code sections that require defendants to have benefit printouts available for opposing counsel at time of settlement and MSCs, but they're very hard to read. So practice tip, get the benefit printout, but also confirm that information with claims to make sure everything is properly paid so proper credits can be accounted for. Next page, please. All right. So one of the most common trends that there have been issues with, and it's important to not just learn from your own mistakes, but learn from other mistakes as well. But There have been issues recently where in case law comes down on it, talking about if benefits are ongoing, and I'm referring specifically to permanent disability, okay, make sure that the ongoing benefits are listed on pages 5 and 6 of the CNR, okay? Don't just list that they're paid through October 23rd, 2024, okay? If you're still paying ongoing PD, make sure you list and ongoing. Why? Because it keeps everyone aware that PDA is issued between time of execution. Okay, let's say AA's an applicant are signing today, but the order approving CNR is not listed, not issued for another 2 or 3 weeks. Well, guess what? There's probably going to be a PD check that's going to issue between now and the order approving CNR that's not mentioned on the CNR, right? But if you list that the benefits are ongoing, then guess what? They can be deducted from the settlement amount that's listed on page 6. Okay. So again, not brain surgery here, but if the devil is in the details with this stuff, which is a theme that we should all be aware of. But if you do that, then everyone will be on the same page and there won't be any issues later on. Okay. Next page, please. All right. So we're on to page 6 of the settlement. We've all seen this page and it's very important. Keeps everyone on the same page. Next page, please. Okay. Now, of course, list the proper amount of permanent disability paid. That's going back to page 6. The permanent disability totals that you list on page 5 and page 6 should match. If they don't, guess what's going to happen? The judge will notice that, and next thing you know, you have an order suspending, and you got to come back to a hearing in a month. When if you did it on the front end, you wouldn't have to deal with all that headache on the back end. So also list the permanent disability, the dates that they've been paid through. Okay. And if you're seeking any type of temporary disability overpayment, then list the entire amount to be deducted. Again, that's very important, and we'll get into that on the next page or two. Next page, please. Okay. So if you have a temporary disability overpayment, okay, this often comes up in Maple's situation, right? For example, the applicant is declared permanent stationary on January 1, 2024. That's the date of the evaluation with the PQME, January 1. Well, the report doesn't issue till February 1. That leaves all the time for those 31 days, all of January, we're still paying temporary disability, right? Then we get the report a month later and we're like, oh, guess what? There's an overpayment. Well, that's a common situation that arises, i.e. Maples. Maples does allow credit to be sought in those situations, but when you do so, make sure you spell out why you're seeking the overpayment. That's just a communication that you have with the judge saying, hey, look, this is why we're seeking that overpayment, to make sure there's not any type of issue that the judge says, wait, hold on, where's this coming from? If you're detailed on the front end, it really just keeps everyone on the same page throughout the whole entire settlement process. Next page, please. All right. Now, regarding liens, actually, before I get to liens, everyone, make sure the math on page 6 matches. I know it's things that we're all, most of us are very aware of that, but you'd be surprised how often judges, obviously, they get their calculators out, just like we all do, to make sure that the settlement on page 6 is all proper. But let's all make sure it matches. If it doesn't, it's sloppy. No one wins with incorrect math. And there's nothing more embarrassing than having to get an order suspending when simple math could have prevented an issue with that, right? So moving on to liens, a practice tip that I recommend is, indicate that liens will be negotiated or litigated. Nothing uncommon there. We're all used to that. If the lien is resolved, but it remains on the address record, indicate that. That way you won't have to have a judge setting a case for a lien conference when you can kind of communicate on the CNR that, hey, look, it might be on the address record, but judge, don't set it for a lien conference on your own motion. It's already resolved. Next page, please. All right. EDD. Okay, this is a recent trend that has been arising that we should all be aware of. One of the biggest things I would recommend doing with this issue is never treat the address record as being a true reflection of whether EDD has paid benefits. Okay. I would say probably 20 years ago, the address record was a little bit more reliable with regards to confirming whether EDD has paid. But nowadays, EDD won't really file anything reflecting they've paid anything for the address record. So you can't just rely on that. Okay. So what does that mean? That means that you should always, in my opinion, always, I don't care if you are settling with a Thomas finding for $2 or, $2 million 100% or 99% PD case, always check with EDD. Why? Because you'd be surprised as to how often they've paid benefits, but guess what? You never knew about it. Why? EDD may have paid, they may have served the wrong address, or they may have not notified the proper parties, or they paid when the applicant was unrepresented. For whatever reason, they paid benefits and they may pay duplicate benefits, right? But if you contact EDD, and if you're aware of that on the front end before you finalize settlement, then if there's any scenario whereby you may have paid concurrent TD and concurrent state disability benefits, then you can always take credit from settlement prior to the settlements being paid out. Okay. For example, we've all seen the scenario where settlement is for $10,000. Okay. But prior to settlement, we realized, wait, hold on. $2,000 was received by the applicant in temporary disability during the same time frame where the applicant also received $2,000 in state disability. Okay. It doesn't mean that the applicant was trying to be frivolous or fraudulent, but it does happen. Well, in those situations, you tell the other side, hey, look, AA, we've have a scenario whereby there's $2,000 that needs to get paid back by EDD. We're not going to pay it because it's not our issue, it's not our error. It's going to have to come out of applicant settlement. So when EDD comes out with their hands across saying, hey, someone pay us back, you want to make sure there is someone to pay them back, for example, applicant settlement. But if you don't find that out for 6 months or 6 years after the CNR, guess what? Applicant's already spent his or her money by then. Meanwhile, EDD is going to come back to defendant and say, hey, we don't care who pays us back. Well, guess who's going to pay him back? Probably defendant. So check with EDD beforehand, keep it simple, and you'll be concise. JP, did you have something?
Yes, I wanted to quickly interrupt. We had a very good question that I wanted answered on screen. The question is, what about child support liens? How do we, or when do we address? Who is supposed to address? How is that approached in CNRs or in settlement in general?
Oh, great question. Very good question. Child support liens are similar to state disability liens. There's much less friction you'll get from an AA trying to dispute that the child support lien should not be paid back from settlement because of public policy reasons. Obviously, we want to make sure that most parties are comfortable with that amount being reimbursed from settlements, paid deducted from settlement. What I would recommend doing is make sure that you get everyone on the same page, contact child support, specifically through the county. Usually the state disability rep will not have that information. You usually have to go through the county directly. County does have representatives that deal with these settlements. Get all that information up front. And when you get that information, relay that right away to the opposing side. Say, hey, look, we have a lien for X amount of money. That's going to have to get paid back from the settlement. And then once you get everyone on the same page, make sure you list that on page 6 of the settlement. So under the settlement of CNR, list underneath there less blank amount of money, and then next to it say payable to Alameda County, whatever county of child support services. And then you can list that on page 6 in your liens area, say the payment will be made to blank child support services to be deducted from applicant settlement. Just have the lien signed off by the Department of Child Support Services, and then you should be good to go. So you that's how I think it's mostly dealt with, but that's why it's always good to check with EDD and check your address record to see if there's any child support issue. But again, there's usually less of any pushback from an AA when you have child support, just because if it's there outstanding, then it's going to be deducted from the settlement. All right, great question.
Nas, I have one more very quick question.
Yes.
It's a little bit vague, but the question is, do you recommend we attempt to take a credit without a petition? It didn't indicate if it's a credit for PD advances or TD advances, but since the law on that is different, I'll have you answer both. PD, a credit without a petition for PD and or TD advances.
Great question. JP, do you want to answer that, or anyone else on the line? That way I'm not the only one speaking.
Oh,
It's a great
yeah,
question.
sure. Okay, I can answer that. So if it's
Great
going to be
question.
a credit for permanent disability advances, as indicated earlier in Nas's slides, you can take credit for PD advances without a petition as long as they are noted somewhere on the CNR that you are taking credit for those advances for permanent disability. Now, regarding temporary disability, the Labor Code does not allow, again, does not allow unilateral credits for temporary disability without either an agreement by the parties or petition/order from the judge. So if that's going to be an issue for you, as we're all aware, generally you're going to see a situation where TD is ongoing, the QME eval happens, and obviously there's going to be generally a delay between when the eval happened and the report comes out. We as the defense side are not allowed to take a unilateral credit. You'll either need to try and work out a deal with the AA, have your bring that to the attention of your defense attorney, but in general, or not in general, you are not allowed to take a unilateral credit on temporary disability without prior agreement or order.
Thank you. Thanks, JP. Feel free to jump on in. Questions are always appreciated. So keep sending them in, and JP, keep interrupting me from talking whenever you have to. Thank you. All right. So next slide, please. The beautiful page 7, and it's all in its infinite glory, huh? Page 7 it is. Should we take a brief second and stare at that, page 7? Okay, never mind. All right, let's move on. All right, so page 7, and it's all in its glory. Make sure you initial everything. I don't see why you wouldn't initial everything. The only thing we don't initial post, I think 2016, don't quote me, but just try not to initial the SJDB unless if it's for an older injury. But that doesn't mean you can't still preserve your defenses. If you cannot initial on, okay, how about this? If the case is denied and you cannot initial resolution of the voucher, does that mean that all is for naught? No, because you can still add in that, hey, defendant reserves all rights regarding Beltron, which relates to denied cases and vouchers, as well as Thomas, which relates to denied cases. Put that on page 7 of the CNR, say, hey, we reserve our rights pursuant to Beltron and Thomas. That reserves all rights later on as well. Add an addenda as well if you have to, of course. And as far as page 7 goes, in the comments section, treat that as your communication to the judge. Explain how the settlement was reached, okay? Keep it simple. All you have to list is, hey, list the PD reporting that's being relied upon, list the date of the report, and list the PD rating. You don't have to have 9 paragraphs in there. You just have to communicate how the settlement is adequate, keep it simple, and move on. Next page, please. All right, page 8. Next page, please. All right, for page 8, keep it simple. Just in the designated area, sign and date. There are certain judges, Judge Shields in Oakland was one of them, who was notorious for this in a good way. If the attorney did not sign in the right section, then he would not approve a CNR. Why? Because if you're signing as an AA, but you're a defense attorney, or if the defense attorney signs under the applicant signature line, guess what? It's improper. Just take your time, do it right, and don't do it again. Move on, please. All right, next page, please. All right, settlement addenda. Of course, no one is required to include addenda, but we should probably all be including addenda, in my opinion, whenever you're settling future medical care. So this kind of a rough example of one of the types of settlement addenda that is over-encompassing but includes the proper language. Next page, please. So for settlement addenda, make sure you list all the ADJ numbers. As a practice tip, page 1 of the CNR, page 4 of the CNR, and the addenda are the 3 pages where the ADJ numbers should match. So make sure that if you get extra ADJ numbers, make sure that you list them properly on pages 1, 4, and on top of all applicable addenda. Why? Because if you do so, then the order approving CNR should also adequately list all of the dates of injury you're resolving, okay? Now, know your board. What does that mean? Well, some boards have certain judges which they approve certain language in the addenda. Some boards don't. So just be familiar with your board. If you're not sure, reach out to your attorney. We should know with the judges pretty completely as far as what can pass, what cannot pass. If you need a Medicare set aside, then include the proper addenda. Okay. This is where communication is important between claims and counsel, as far as having the proper addenda. If you need an MSA, then indicate that in the addenda. If you have one, indicate so. If you have CMS approval, I put the CMS document as an addenda because it keeps everyone on the same page as far as adequacy, payment terms, if you have to pay the applicant directly, withhold the money for whatever reason. So those are just things that we should all be considering. Next page, please. All right. So that kind of covers the first half of the presentation. Again, we could all talk for hours and hours and hours about settlements and trends. I didn't even get into things like stipulations, which have their own type of specificities. But if anything does come up as to any CNRs or questions later on, feel free to reach out, and we'd be happy to cover any questions. So my next line of training or webinar discussions will be about panel trends. Okay. But before I get into panel trends and the exciting panel trends that are out there, I get to tell one more bad joke. Okay. A man sued his airline company after the company lost his luggage. Sadly, the man lost his case. All right, next one, please. All right, so panel trends, okay? For trend purposes, again, we could go on hours and hours and hours, talk about Labor Code Section 4060, Labor Code Section 4061, and Labor Code Section 4062. Okay, but for time purposes, of course, we're going to kind of keep it a little more limited today to Labor Code Section 4060. 4060 applies for delayed and denied cases only. Okay, so here, right here, this is the page that whoever's requested the panel, this is from the DIR website, and it's the online first page of the form. Before I move on, I believe there's some questions that did pop in. JP, did you want to feel free to jump in and interrupt me whenever you want? We can ask some questions before I move on.
Yes, I did just get an interesting partial question. Somebody was asking if anyone is getting rejections or trouble regarding wet signatures on settlements versus not. Me personally, I have never seen a judge reject a e-signed settlement versus a wet signed settlement. Other boards, of course, may vary, but I believe, and it may not be covered in this because it just happened, I believe the governor just signed some recent legislation, which we'll have to look into, about allowing e-signatures for settlement agreements. I'll have to look into that further. However, me personally, in the boards that I practice in, I have never had a settlement rejected for an e-signature versus a wet signature.
A great question. I think with signatures, there's the pre-COVID world, which was before March 2020, when signatures were obviously fine, handwritten, or however you want to do it. Then there was a COVID world from, I think, March 2020 until late 2022, when Governor Newsom changed some of the laws as far as the signatures go. And then there's now, which is from kind of 2022 through current, which is a little bit different. But as far as Oakland, San Francisco goes, I've not seen any issues with that type of question, as long as it shows that there's no doubt as to the signature, either e-signed or wet signature, it's gotten approved. But good question. Who knows how the trend is going to be this time next year or 5 years from now. But I haven't seen any of those issues at the boards that we practice in the Bay Area.
And I am seeing some other people mention varying results in the question box. So my suggestion there is, if you are not sure about your local jurisdiction, go ahead and reach out to again, key here is your local B&B attorney who's familiar with the judges in that locale, just to see the trends and how the judges have been reacting. Like I said, with this new legislation, it may be a non-issue, as Nasir had said, in about a year, end of this year, middle of next year. But for now, if you've got pending settlements, go ahead and reach out to your local B&B attorney to see what they've seen in their venue.
That allows me to do a not so shameless plug. Our office does cover every single board in the state, and our office, our firm has attorneys who know every single board in the state. So if you're not sure, email us directly afterwards. We can help you answer any type of questions related to settlements, including signatures if they pop up. Thank you for that question. So next page, please. All right, so with panels, just like I've been saying with settlements, the devil is in the details, okay? Be very careful to list the proper claim number when you are requesting a panel. If you do not list the proper claim number, for example, if you missed one letter, one dash, one whatever, then the med unit is not going to recognize that because it's an online request form, and then you're going to have two separate panels that get issued, okay? So even if you're online at the same time as opposing counsel, but your panel lists the wrong claim number, then guess what? Your claim your panel's probably going to be defective. So just be careful, be concise, be detailed on the front end, and it's going to prevent some issues on the latter end. If you have if you have a cumulative trauma injury, then make sure you properly list that in your panel request. The end of the CT is the injury date that you'd list on the panel request form on the first page in that situation. When you're on the first page of your panel, don't hurry. Properly list the PTP's name, especially if the PTP is unknown, then it'll give you a prompt that says you could put unknown in the first and the last name. These things it's not the most complex things, right? But if you don't properly do it adequately on the front end, then it's going to lead to a defective panel. And it could be the difference between, hey, getting a conservative or defense-friendly orthopedic panel versus getting the not so conservative, not so friendly chiro panel, right? So a little bit of time on the front end saves a lot of exposure and headache on the back end. Now, for those of us who know, 4060 relates to denied and delayed cases. We've established that 4061 and 4062 relate to accepted cases. And each of those labor code sections have separate requirements relating to triggering of the objection process and panel issuance. Next page, please. Now, today we're going to be dealing primarily with labor code section 4060, and that only relates to delayed and denied cases, okay? So when we're dealing with delayed and denied cases, there are certain situations that come up, and I'll kind of ask this out loud, and I can't really get answers directed at me right now, but let's say a situation arises where a case is partially accepted. So let's say the neck and the back are accepted, but the toes are denied. And the claims will send out a partial denial saying the toes are denied. Of course, the back and the neck are accepted. So in a partial denial case, does that give rise to a request under Labor Code section 4060? I can sense a lot of heads nodding and shaking, but the answer is no. Partial denial does not allow for a Labor Code section 4060 request. Why? Because a partial denial is still an accepted case. Even if it's partially accepted, that means it's outside the purview of Labor Code section 4060. Right? So one thing I will say is that the recent trend we're going to get into is, unlike before, the trend is that AAs and applicants can now start the Labor Code section 4060 process. Before, until about 2022, the only thing that could trigger the 4060 process would be the actual formal delay or the actual formal deny letter. Once that gets sent out, then and only then could the 4060 process commence. But now that law has changed with recent trends. Next page, please. Okay, so here's an example, okay? Now, an AA can start the 4060 process. They can do so as indicated here. They could just say the following language: hey, claims, or hey, defense attorney, compensability is at issue and the parties need a QME. They will request a 4060 panel accordingly. So be aware, 4060 panels can, and the trend I've seen 2 in the last month alone up in the Bay Area where AAs will start the process on their own. And the initial gut instinct is like, wait, you can't do that. There's no delay that's been sent out. There's been no denial. You can't do that. But guess what? They now can do that. So under those situations, when you see an objection under 4060, then you would have to wait 10 days plus 5 from AA's letter to request a QME panel. And the board reasoning relating to that has been that The injured worker does not have to wait for a defendant's delay or denial letter for requesting a panel to address compensability, as that would create an unnecessary delay and undercut the stated purpose of Senate Bill 863. Now, my gut tells me that in the next year or two, we're gonna have a lot more litigated cases on this particular issue, because there does leave a lot of gray areas to, okay, look, well, what if the delay or denial issues right after that objection letter from AA, right? So just know your facts. There's a lot of pending litigation out there, depending on the facts, that we're probably going to have answered by the board soon. But for now, just be aware that if you get a letter from AAs or applicants objecting under 4060 and the case is delayed or denied, then guess what? Be aware that you can request a panel based on their denial or based on their communication reflecting the same. All right. Next page, please. All right. So again, if anyone has any questions about either settlements or panel trends, reach out to us. If you get a panel, if you're not sure about the doctor, the chiro, the ortho, the pain, whatever doctor, feel free to reach out to us if you have any questions. Before I get in the last topic, I see a lot more questions coming in. So JP, if you have any questions that you want to point out, feel free to jump on in whenever you want.
Yes, I'm trying to select a good one here that I was reserving for you. All right. So we have this is a good question here. If talking about a denied claim, settling via CNR before the QME appointment and no medicals, the question is, what body parts should they list on the settlement document? Only the body parts listed on the application, or all the other body parts that the applicant is complaining about. Unclear how they found out about the other body parts being complained about. Normally we see that in a medical, right? But the question is, if you're resolving a denied case, what body parts should you list in the CNR? Just the ones listed on the app, or all the body parts being referenced by the applicant?
Very good question. You're settling early, so you want to avoid exposure later. So in that situation, there's no medical, so obviously we can't list anything that's diagnosed or provided impairment for. But I would start with the following framework: be over inclusive as possible. You lose nothing as far as listing everything known under the sun, for trying to list as many body parts as possible on the CNR, right? It protects you on the front end, it protects you on the back end. So that's the first and foremost. List every single body part that you can think of. So start with the application. If it's pled, then it absolutely needs to be in the CNR. When you don't have a medical, like there's no PTP at all, there's no PQME at all, the judge is going to ask, well, what are you basing your body parts that you're resolving based on? Then you can list, hey, not only are you listing everything that's on the app, but in your situation under that question, if something's being complained of, if it lists on the claim form, on the 5020, on any type of pleading whatsoever, make sure you put that in there. You lose nothing by being over-inclusive on a CNR, right? So be over-inclusive, list it all, and it protects you, I think, later on down the road. But yeah, so JP, if you have anything to add, feel free to do so, though.
No, not on that question. We had another question regarding Nasir, your last slide regarding if AA sends their 4060 compensability request. This is I believe it's a mailbox rule. So I'll add, two people had similar questions, so we'll go ahead and I can go ahead and answer that. So when you're looking at AA's objection, or in this case, in the slide here, we're looking at AA's request for compensability exam, the analysis is going to be the same. Assuming they are serving you, the claims adjuster, and normally, I believe your addresses are out of state, right? Gallagher Bassett has it in Iowa, and Sedgwick has it in Kentucky. So if you're looking at an out of state service, you look at who is the letter being sent to. So if it's being sent to you at your official mailing address out of state, then it's 10 plus 10, so 20 days. If it's being served to you in California, and I'm not sure if any of our clients have mailing addresses within California, but you look at the mailing address on the official address record. Somebody had asked, well, what if it's sent by email and not by US mail? That's not determinative. What's determinative is the official mailing address on the official address record, and normally that's going to be, well, not normally, that is posted on EAMS, and it's usually your out-of-state address. So what you want to look at to analyze that question is, where is the letter being sent to? Is it in-state or out-of-state?
And that's very important. If it's out of state, then you would allow an extra 5. So it would be 10 plus 10. If it's in state, it's 10 plus 5. So again, these topics, we could go on these tangents and talk it extensively forever, because they do present a lot more tunnels for us to dig through. But those are just the general rules that we should be aware of as far as mailing goes out, and how that relates to the panel request to make sure it's not premature and defective. All right, so if anything else comes up, JP, feel free to interrupt and we can ask away. Now, my next slides are going to be related to aggravation versus exacerbation. And if you made it this far, you get to hear one more, I promise, last joke, I promise. Why don't lawyers play hide and seek? Why don't lawyers play hide and seek? Sadly, because no one would ever come look for us. All right. So on to aggravation and exacerbation. How does it come to play? Okay, a lot of us become experts on this issue, and then we kind of forget the difference between the two. But remember, an aggravation is an injury. An injury is compensable if and when a subsequent work injury lights up, aggravates, or accelerates a previously existing disease or condition resulting in disability. So an aggravation is an increase in the severity of a pre-existing condition in which the underlying pathology is permanently moved to a higher level. Okay, so think, you have an issue, then you have a subsequent issue that gets permanently raised to a higher level. Okay, so it's an increase in severity. That's an aggravation. What's an exacerbation then? Well, an exacerbation is a temporary increase in the symptoms of a pre-existing condition that returns to its previous level within a reasonable period of time. Okay, so again, aggravation and exacerbation are kind of like cousins, right? They're first cousins, but an aggravation gets permanently moved to a new level, but an exacerbation goes back to a returns to its previous level or less. So rather than confusing everyone with a bunch of pointings and narrowings and everything else, let's just discuss that. But an exacerbation and its application, an exacerbation is not a new injury. It's merely a temporary flare-up of a symptom. Okay. So let's go ahead and move on, please. So here we go. Actually, can we go back to the last one, please, Tammy? Thank you. So when a subsequent injury lights up, aggravates, or accelerates a prior existing condition or disease resulting in disability, guess what? That is compensable. So an employer is liable even though the injury would not have affected the employee if the employee had a stronger or healthier constitution, and even though another person would not have been affected by the same circumstances. Next slide, please. Okay. So the common application or set of facts exemplifying how an injury is compensable when a subsequent work injury lights up, aggravates, or accelerates a previously existing disease or condition resulting in disability. Now, these are some examples that we have. Generally, in workers' compensation, causation is a very low threshold, which unfortunately a lot of us are aware of. But here's just some examples that we should be aware of as to how the common application of an aggravation would take place. Next slide, please. So the first example here is the common first year of law school 1L torts class that's commonly known as the eggshell plaintiff rule. In a common application, if an employer hires someone who is as delicate as an eggshell, and if they get hurt at work, then they are entitled to benefits even if another person of normal constitution would not have been hurt. Okay. Now, in contrast, we have the second example where an industrial injury merely calls attention to a pre-existing or non-industrial condition that does not aggravate it. Okay. Now, in that situation, the second hypo, the employer would not be liable for treatment or benefits for the non-industrial condition. Okay. But of course, there's always exceptions to everything, And number 3 would be one of the different exceptions that an employer is obligated to treat a non-industrial condition when it's necessary to do so in order to treat the industrial problem. For those of us who are a little more experienced, we understand that that can come up in situations where you have an orthopedic injury. Well, the orthopedic injury cannot improve, or the orthopedic treatment cannot take place until non-industrial diabetes is taken care of. So those hypotheticals, those situations do arise where you would have to treat the non-industrial condition if it's necessary to treat the industrial problem. Okay. Next slide, please. All right. So aggravation versus apportionment. Okay. The best situation for a defense side is usually exacerbation, right? Because if it's an exacerbation, it's usually not a new injury. But let's say that you do it with an aggravation instead. Well, all is not lost, because if you have an aggravation, then even though there might be a new injury, you can always try and recommend being very aggressive, because there's probably going to be apportionment. Okay. Now, aggravation, of course, deals with causation, but apportionment, as we all know, deals with permanent disability and the goal of reducing permanent disability, specifically due to the non-industrial or pre-existing factors that are out there for the particular applicant. Okay. Next slide, please. Okay. So here we go. Here's some other examples that we have. Apportionment does not apply to temporary disability and medical treatment, as we know. Apportionment does apply to permanent disability. So these are some factors for us to consider. Remember that any causal link between the care and the injury is sufficient. So these are some slides for us to review. Next one, please. Okay. Permanent versus temporary aggravation or exacerbation. The second bullet point is pretty important for us here. Sometimes the issue is addressed as a distinction between an aggravation and exacerbation. The appeals board has explained that an aggravation is an increase in the severity of a pre-existing condition in which the underlying pathology is permanently moved to a higher level. Again, in summary, an exacerbation is a temporary increase in the symptoms of a pre-existing condition that returns to its previous level within a reasonable period of time. And of course, there's distinctions that follow. Next slide, please. Next slide, please. Next slide, please. And next slide, please. One more slide, please. All right, thank you. So here's a cheat sheet here we got going on. Just how to remember an aggravation that causes an employee to sustain indemnity. Meanwhile, an exacerbation is just a mere temporary flare-up, and some examples for us to keep in mind as we move on. Next slide, please. All right. So here's one report that we have from a medical report. Don't need to read the entire medical, but regarding causation, I can't zoom in on this, but the most important thing here is just, if you have a doctor, make sure that the doctor is aware of everything you have as far as pre-existing issues go. Write to the doctor. If there's anything beneficial that's come out from the recent regs, which allow the doctor to get paid at a higher rate as a med legal evaluator for reviewing records, is now that they're much more detailed with regards to the cover letters and the enclosures, i.e. subpoenaed records and medicals that are being sent. So if you have an issue with causation, if you have a case where causation is an issue, make sure you tell your doctor, make sure you spell that out, okay? Because if you do spell that out on the front end, chances are they'll be more detailed and they'll possibly even rule in our favor as far as exacerbation goes. Here, the most important language on this screen is where the doctor says, more likely than not, the applicant's musculoskeletal complaints following an injury are not causally related to work activities. So again, if there's pre-existing issues, make sure you spell that out, because you should be aggressive and try and get the best report possible for our efforts. Moving on, next page, please. All right. So we've dealt with a lot over the last 57 minutes. We can, again, keep talking afterwards if anyone has any questions, but if there are any questions for the last 1 or 2 minutes, feel free to bring them up. Hopefully we can try and answer as many as possible.
There is one brief announcement that some of our Southern California colleagues had mentioned. It looks like some of the Southern California judges are also requesting wet signatures. So since it looks like there is another variance between the NorCal and SoCal boards, if in doubt, reach out to your local B&B attorney to see what trends they're noticing in their home jurisdiction. But again, with the new legislation signed by the governor, that may be a moot point in the next 6 months or so here. We had a really interesting question. Someone had mentioned that a local AA in their jurisdiction has been filing multiple applications for CTs to overlapping body parts that are 1 day apart of each other. This person has noticed that this is becoming very common where they're at, probably assuming with the same AA. Is there any way, the question is there any way to get these consolidated or I'm sorry, is there any way to get these consolidated as it is affecting the mod rates of their employers?
File for hearing. I would file for hearing on it right away. Say, hey, look, something, if it doesn't smell right, it's probably not right. You might as well get the judge involved and say, hey, look, if you're dealing with that issue, chances are that same attorney is filing those same claims all over that venue. So I would file for hearing, bring it to the judge's attention. If you can't slap him or her on the wrist, a judge needs to, but something needs to get resolved with that because it seems frivolous as all heck to me.
Let me see.
Okay. I think we are about out of time here. We've just got a few seconds left. I don't want to hold you guys over. I know a lot of you do this on your lunch hour. I'd like to just really quickly thank the attendees for all the fantastic questions. I think when you ask all these questions, it makes it a lot more interactive and a lot more fun. And I want to give a big thank you to Nasir and JP for a great presentation. And most importantly, for some fantastic jokes. I don't think anyone has ever given jokes throughout the presentation. So you are the new star, Nasir. And I don't think I've heard that attorney joke before, and I laughed out loud, so good job. Hopefully you guys are laughing over there too, and I hope you guys learned a ton of stuff today. Thank you all so much for joining us today. Have a great rest of your week, everyone.
Thank you, everyone.